One, two. Is this on? Welcome to another answer to the age-old question of, do you know what really burns my ass? The way different game companies design their rule systems. A lot of people, both game masters and even game designers, don't know how rule systems are protected by law. There are three types of legal protections for board games: trademarks, copyrights, and patents. These are all separate and distinct. A lot of people think that copyright is the legal protection of all intellectual property, but there are a lot of specifics and what if around copyright. Copyright in the United States is the legal protection of original works of authorship, including books, music, art, software, etc., as soon as they are fixed in a tangible expression. Recently, digital expressions have been specified as tangible. A trademark, in comparison, is a recognizable word, phrase, symbol, etc., that identifies the source of goods or services. This distinguishes a company from its competitors. A patent is an exclusive right that provides ownership and authority to exclude people or companies other than the inventor to make, use, sell the invention for a limited period of time, usually around 20 years. Marvel and DC are probably the easiest examples of trademark wars in the US to understand. You see, DC created Superman and Wonder Woman. Marvel created Wonder Man. He just recently had a TV show on Disney Plus. So DC got upset and said, "You can't have Wonder Man, we already have Wonder Woman." So Marvel killed off Wonder Man. Later, they created Power Man, who is not related in any way. But then DC created Power Girl. And that made the people at Marvel upset, and things just kind of escalated from there. Another great example is Marvel, of course, has a license to Spider-Man, and licensed that trademark to an animation company, who let the license expire, and then they gender swapped the character so that it would be new and they wouldn't have to pay for the license. Stan Lee found out about this during a golf game and just fast-tracked the debut of Spider-Woman to publication to establish the trademark. This is how we got the Web Woman cartoon from Filmation, who is a separate character from Marvel's Web Woman, who, so far as I can find, only appeared in a single Spider-Man Hostess ad. So how does this affect board games or role-playing games? You see, the trademark is the brand. Dungeons & Dragons is a trademark. Settlers of Catan is a trademark. Interestingly, Catan is a separate trademark owned by a different company, even though it's the same game. The copyright is the D&D Player's Handbook or the Catan Rulebook, which, like I say, is the same between the two companies because one bought the other. These protections are well known in the gaming community, although they are often confused for each other. Lesser known is the patent. Louis Zocchi invented the D100, commonly known as the Zocchihedron, in 1985. His patent lasted, as I said, 20 years as a standard, after which he modified and improved the design so that it settled on a number faster. So that way he got a new patent, and other companies couldn't make the Zocchihedron, only he could for another 20 years. But this isn't the only gaming patent, obviously. Wizards of the Coast owns 5 different patents to protect their Pokemon and Magic the Gathering card games. They have none for Dungeons & Dragons, although their website warns that infringing on their D&D patent can land companies in legal trouble. Since January 1978, a copyright cannot protect a procedure regardless of how it is described, illustrated, whatever. This includes the stereotypical game mechanic in American board games of generate a random number, move your pawn along the track, do what it says on the space you land on. I seem to recall that there was a legal issue, and that's what led to the change, but I couldn't confirm that in my research before this video. But this is why pre-1978, many games from different companies, Parker Brothers, Hasbro, etc., delve into different methods of generating that random number, or different ways of expressing the space you land on, or different shapes of the track. I'm talking about Monopoly, Sorry, Bonkers, all of those. These had differences because those differences could be copyrighted. And a lot of differences between games currently exist because that just used to be the law. For example, Dungeons & Dragons. You can't copyright the idea of generating a random number from 1 to 20, adding a series of modifiers to it to determine success or failure. But this is the way D&D has worked since the release of 3rd edition in 2000. And while it would not be a copyright, trademark, or patent violation for another game company to also generate a random number from 1 to 20 and add a series of modifiers to determine success or failure, so far as I'm aware, only Pathfinder has copied that procedure. As we progress through this series, I'm going to discuss different role-playing games and the mechanics they have. And while I don't know that some of the game decisions are just to be different, I'm 100% sure that some of the decisions were made just to be different from more established systems. I do want to close today with a little explanation of American copyright law, because this has been a low-key hobby of mine for over 30 years. So here's my understanding what copyright is not. Copyright specifically does not protect ideas, processes, procedures, systems, concepts, or discovery, regardless of the description, explanation, illustration, or embodiment. This is a source of a lot of misinformation. A lot of people think that copyright protects the description even if it doesn't protect the idea being described. It doesn't do that. Also, copyright does not protect people from using the ideas or information revealed by otherwise copyrighted work. It's the specific form in which the author expressed the concept. If I write a song inspired by a book, the copyright on that book doesn't prevent me from also copywriting that song. Finally, copyright is very flexible in the realm of parody. There are two well-publicized court cases, one involving Larry Flynt in 1988 and another in Afroman this year in 2026. These helped solidify parameters for where legal protection of intellectual property ends and freedom of speech begins. I hope you'll still stick with me as we move through various role-playing systems developed in the last 50 or so years and the differences in how they all basically produce the same sort of collaborative experience. Put something in the comments. Let me know what game system you enjoy. I'm reading all of the comments, and this will help me know which game systems to focus on as I continue to talk about this.